44 with Dennis Woodlands. Thank you.
Sure. Thank you. So I'm just going to kind of cover these thematically more so than looking at the specific statutes or proposed changes altogether. So for the 1205 amendments, I think it was pretty well covered. One point of reference, the current way that 1205 reads is it says at the limit that is set under 1201. And that's why I think that they thought that they were getting to 08 or above, but we've had some courts toss when we have a 08 exactly, which is incredibly rare, but has occurred. With regard to the criminal refusal warrant, we support this measure because partially also because of court order. And what we're talking about here is violating a court order, which is not generally allowed. Somebody shows up at your door, an law enforcement officer shows up at your door with a warrant, you can't just tell them to pound sand. Other states, the way they've addressed this, many of them have addressed it by allowing forced blood draws. I would never advocate for that sort of thing. If I was asked to, I wouldn't be here testifying. And so one means of addressing the wrongdoing is as a DUI refusal charge. Additionally, it also triggers a lot of the rehabilitative measures that we've been discussing for the last couple of days here.
So are you on page 4? Is that for that provision?
Yes, I don't have the
100
for numbers. Say
that on 1201 B2. Is that what you're talking?
Yes.
So can you just tell me? I mean, it's shall not refuse, but what if they refuse? I mean, it's just that language is.
So we run into folks who refuse all the time. They have a constitutional right to do so. Both state and federal constitutions well laid out that you have a right to refuse a search in that regard. And so then you're
warrant or is
yeah. So the request, and even with a warrant, you see people refusing, and they can get charged with a refusal if they have a DUI 2 conviction or above.
Okay, if you back up, I want to make sure I
Sure.
what you understand this. So the request, you can just refuse. All right,
Correct.
so that happens. Now you have a warrant.
Yes.
And you can still refuse, and there will be consequences.
Well, now the consequences are if you have a prior conviction,
Okay.
then it's a refusal essentially. The other consequences are, as you heard, folks have been charging impeding and or obstruction. I think impeding is probably more factually correct as far as meeting the elements are concerned, because you have two requests here. You have law enforcement officer's request, and you have a request from a judicial officer, an order, in fact, from the court. For example, a court may order you not to have contact with certain people. And if you violate that, it's a crime of violating that order. That's simply what we're asking for here, is violating the order that you submit to the order.
Okay, and that's the language here. I guess I was just kind of curious if, as far as the way that it's worded, you say you shall not refuse. Does it make more sense that it's just clearly stating that if the person refuses, this is the consequence? I mean, because now you kind of have to bounce to a different section to see what the consequence is.
Yeah, and that's part of because of how we have the statute initially drafted. That's a function of how it's laid out under 1201, is where we have kind of like step by step by step, and shall not refuse is essentially stating the status of the law. You're not entitled to refuse the request in the proposal.
Okay. All right. Thank you.
And then I think I'm going to look at the 1091, 23 VSA 1091 proposal first, which is the conforming the SBI, the serious bodily injury and death resulting. So in 2007, the legislature attempted to do that. I don't remember what page that's on.
So before you do that, I apologize. So, but is 1202, specifically looking at page 10, the provision, what was it? D6C, isn't that
Yes.
kind of part of what we're just talking about with the section 1201, B2? Aren't those two kind of connected?
They are interconnected in that, for purposes of implied consent, a law enforcement officer has to read certain warnings to an individual, and this adds that as one of the implied consent rights, that you have to be read that, you shall, what is it said, refuse to comply with a search warrant that is obtained by a law enforcement officer pursuant to subsection F of this section. That essentially lays out as part of the implied consent process that this is one of the steps that has to be covered.
So this may be a bigger discussion that Tom Oliver and I talked about, and I don't know if this is the time to dig into this at all, but really a question of implied consent. And if you could tell me how that works at the roadside as far as getting, it doesn't sound like it sounds like you have some consent at the roadside of this individual or in when you've arrested them or what, like sometime in the process.
Sure.
Not just implied, it's like actually the person has to consent. Is that not?
Yeah, so the way that the statute's drafted is that upon request from a law enforcement officer for an evidentiary test, so we're not really talking about the roadside interaction at this point. We're really talking about back at the station house when they're being processed.
Okay.
And so at that point, the officer goes through all of the implied consent rights to ensure that the person is informed of them before they have their conversation with the defense attorney. And so at that point, they say, are you going to, do you acknowledge and so on? And they sign off on it. You want to talk to a lawyer and that sort of thing. And then the conversation occurs.
So I guess the fundamental question is, I understand, Tom, tell me if I'm misunderstanding it. How can somebody that's blowing a .16 or whatever, how can they consent to anything?
So we're talking about legal consent here and whether or not a person is actually incapacitated to the point where they can't consent to commit certain things. That's a legal standard. And you have to be essentially at the point where you don't really even comprehend what you're doing. And they also look at whether or not you have gotten yourself to that level versus somebody else has gotten yourself to that level. So it would be akin to, for example, if someone can consent to sexual intercourse, for example, you have to know what the consequences could be. You have to know what you're engaging in. Same kinds of questions that are asked in a legal sense.
Yeah, Tom.
So if somebody just made a bad decision because they're how are they going to be making more good decisions about their legal future when they're doing being processed for DUI? I've processed a lot of DUI.
Sure.
And what my go away from that is a lot of people really understand, some understand all of it. If they're highly intoxicated, they sometimes say they understand, but clearly they don't. You have to call a lawyer 3 and 4 times before they will even get through what you're trying to give them. So I'm not so sure all the time that it's appropriate to go through implied consent. If implied consent is something about getting a driver's license, you're consenting to this to happen. Maybe it should happen there, which is on the form when you're on a DUI stop.
I can't answer that question.
No, I know. I'm just throwing out that
above my
thought. Because it's very convoluted and complex, even for someone. I gave it a copy of it a minute ago to the chair, and if you read it, it's like reading it. And you expect somebody who's impaired to understand what we just imparted to them.
With your experience, I'm sure that you saw the progression of how long processing started to take.
Yeah.
To the point we talked about blood tests, for example, average blood test time from time of the stop to the time of the draw is 2 to 4 hours after.
It's literally you go up to you make contact with the car. So everything we do here matters at the end, what's going to happen out there, the end user, right? You walk up to the car, you make your initial contact, you go back to the car, go, oh, okay, I'm gonna have to dig up my briefcase and get all this stuff together. I mean, it's,
And I mean, I can take partial responsibility for why it takes so long.
No,
Because I'm an
I-
attorney and I was a defense attorney before and, you know,
Right.
so we have litigated these matters, you know, historically, and that's what's drawn it out.
conversely, I appreciate the processing form and the affidavit structure because it really walks you through the whole. You just have to figure out a system to make it work. First two are pretty rocky.
I can imagine.
So this is a deeper issue that, I mean, I'm very curious along the lines of when you get a driver's license, should things become a little clearer at that point in time that these are the things that you are consenting to by getting the driver's license, which includes what otherwise would be asked at the roadside, or if that's just not doable because of precedent and due process issues.
I don't think,
Not something we're going to resolve right today.
yeah,
So,
from my perspective, and maybe, you know, Marshall might speak to that later, I don't think that that would present as any due process issues. DMV might have a problem with the extra printing costs, you know.
Right. Yeah, well, we'll ask DMV that as well. But anyway, I bring it up because we have implied consent in this bill.
Yeah. No, I'm happy to try to address it as best I can.
Okay, so anyway, back to you wherever you were next.
So,
I'm sorry, Ken has a question.
Sure.
Do we have anybody in this room that can make this process easier and less complicated and we can get right to the point and
That's what I was just asking about, yeah. Yeah,
I mean, it's really, you all could make it easier.
no, these past groups and everything like this, they love to make it more complicated. That's why we give lawyers jobs. Yeah, bless you.
work with legislative council, come up with something for us.
I'm not sure I can.
All right, over to you, sorry, Nate.
No, that's okay. So 23 VSA 1091,
Do you,
back in,
which page that is?
yeah, that I think is towards the end, right?
Yeah. First?
The
17?
death resulting?
You said?
It starts it for the penalty.
Yeah, it's under penalties. It's
Okay, great.
under 1210.
All right.
Not 1091. I apologize. So, one of the things we're trying to address here is that we ran into a little bit of a drafting problem where if you have two people who are injured or two people who are killed, then they can be separately penalized for that. The defendant can. But if you have one injured or one killed, the language does not reflect that intent. And so what we end up with is amending in order to make it two of the same kind, which seems a ridiculous outcome. When you might have one injured, one killed, it should be that you can penalize that. Does that make sense?
Yeah.
Yeah. And I think that was the intent, if you read the preamble of the passage of that law, Act 195.
Oh, shit. Sorry.
Oh, boy.
No, we're good. As long as my computer didn't get it, we're fine. Obviously, I've not had enough coffee this morning.
Usually too much.
Yeah, it's usually.
I'm leaning that way.
Yeah, proceed.
I don't have to blow my
Okay.
nose the rest.
So the only suggestions I would make is that in reference to Title 13, the reference in the original statute was incorrect. There is no longer just a 1021-2. The appropriate should be 13 VSA 1021, little a, 2, big A, excluding B because we don't think strangulation is an issue in those cases.
Okay, so that should actually be at the.
Yes, and we also think that the heading should be death resulting and serious bodily injury to make it clear that that's what it's referencing. If you look on page 17, line 17.
Okay, super. And your first edit was in the definition section.
Yeah, where it says, thing,
That's a good, yeah, thank you. It's a clear.
I didn't have the pages. the definition of serious bodily injury should be,
Yeah, thanks.
A
13 BSA.
to A.
21 little a.
Right. Yeah.
Okay.
Yeah, should be,
I'll get it downloaded up. Yeah.
the reference point should be little a,
To.
yeah, little a to big A.
And not big D because no string.
No string. Yeah, no string relation.
And that's on page 3.
Yes.
Yeah. Okay.
It would be A to big A only.
It's a good catch.
I can thank Evangeline James, Attorney James for that one. So next, I think it's the juvenile youthful offender reporting. In reviewing this issue, this was brought to my attention by a couple of state's attorneys who were handling juvenile matters, and they learned that the court wasn't reporting DUI adjudications to Department of Motor Vehicles at all across the board, both in youthful offender and juvenile delinquent cases. What we've found since is that some judges are, some judges aren't. And so there's an inconsistency of application, but both Attorney James and myself spent some considerable time reviewing this, and we're both under the impression that it's at this moment still the court's it's still a requirement on the court to report these adjudications, but they are relying on either misinterpretations or a lost interpretation of the statutes themselves. Part of the reasoning is it's based on the overriding confidential nature of proceedings involving both juvenile and youthful offenders. And the other would be the definition of the word conviction. Under Title 33, as we've heard before, adjudications aren't convictions. They're not convictions specifically by statute. And Title 33 also has broad confidentiality provisions. That is despite the fact that Title IV, which actually grants jurisdiction to the family court to hear these cases, uses the word conviction and saying that they have to be reported to DMV. It should be noted that at the time, 5202, which defines, I think it's 5202, right? Marshall, you can correct me if I'm wrong. 5202, which defines these as non-convictions, that was actually law at the time. And so the legislature used the word conviction in Title IV in granting the jurisdiction. In reviewing, I also noticed that they hadn't granted jurisdiction to hear youthful offender cases, which I think was their intention. And so I added 52A, Chapter 52A, as a part of this proposal. It should be noted that at the time, also though, under the Title 23 definition, as you heard, convictions includes adjudications. And we think the language, both Attorney James and I think agree on this, the language is sufficient to cover any adjudication in both juvenile and youthful offender circumstances.
Okay, so we don't have to add actual adjudication under the definition of conviction, in your opinion?
Just because,
It's covered.
right, we're adopting in the proposal the definition that Title 23 applies to the word conviction. And I think that that's why the legislature used the word convictions, because they knew that under Title 23 has a very wide definition. Should also be noted, though, that 52A2 mandates the family court must report negligent operation death resulting cases, for example, and juvenile YO adjudications. for insurance purposes. It mandates that they have to report DUI adjudications for insurance purposes, both under 1201 and 1205, which is interesting because the family court doesn't have jurisdiction to hear 1205 cases at all. It mandates DUI driving license suspended reporting for purposes of insurance. And it seems to me that it would be inconsistent for a requirement that these adjudications be reported to DMV just for insurance purposes, especially when one of those is driving license suspended, DUI suspension. You get me? Right? Because it's clear that they intended that these be reported so that these licenses would be suspended. Further, 33 VSA 5118B allows reports relevant to state agencies for the overriding public purpose of rehabilitating juveniles. As we learned, IDRP would be one of those. 33 VSA 5117B1M allows reporting these to other state agencies, treatment programs, service providers, or those providing direct support to youth for the purpose of providing treatment to the youth. And again, relicensing is predicated upon receiving some form of treatment. I can report that Department of Public Safety supports this proposal, as we do. Department of Motor Vehicles, they're here to speak on what sections of it they support. The problem is that while we believe that it was already legislative intent this be reported, and we already believe that there's a requirement that it be reported, some courts aren't reporting it. And it's going to require a great deal of litigation in order to get there, when we can just simply amend the statutes to make it perfectly clear that they have to report these.
So we probably should have Judge Zone just weigh in on that.
And I was going to suggest that. We did have a juvenile justice meeting involving Judge Zone, where he said, it's not clear to me, I'm not really sure, because of the broad confidentiality provisions. And by the way, you all haven't litigated it.
That's right.
So from our position, we believe that there's already the requirement. We're just trying to shore it up so that we can have all the judges applying it equally. I can tell you that, as a former public defense contractor, I was told, and as a prior defense attorney has testified here today, that you should advise your clients that they're going to lose their license. Probably, we don't know really, and we were advised we should inform them that you'll likely have your license suspended. So we think that it's been the intention all along. It's just that somewhere along the way, someone in Judiciary decided to stop doing this. And I should mention that in our juvenile justice meetings, some from Judiciary were pointing fingers one direction, some from DMV were pointing the other. So there was some conflict as far as that supposition is concerned.
And 5202 presumably resolves this. 33, section 5202, the language that we have here. Am I looking at the place?
The proposed language is what we're talking about, because 5202
Right.
limits it to for insurance purposes, but we're, adding also for suspension. That seems to be what they intended, because it also requires that DMV be that adjudications for DUI, DLS be reported to DMV. And so if they weren't going to suspend them, why are they requiring them to report the suspension? Does that make sense? I misspoke a little bit there. I'm tired.
Makes sense.
And finally, I'm happy to report that you heard from the DRE coordinator. We had all of our interviews yesterday. We're going to have 7 new candidates coming up.
Good. Great. Good to hear. Good to hear. So anything else on H44? I think that covers all the provisions. And any questions, additional questions for Dennis at this point? And there may be, as we talked to other witnesses, we may circle back around with questions for you as well. So you can stick around, and we'll go to Marshall next.
Thank you.
Although I did have, let's go to Marshall next, and then we'll go to.
I'm gonna say we ought. Man,
Yes, go ahead.
I'm gonna say we ought to have Marshall last.
You want Marshall last?
Yeah,
Is that okay?
I'm kind of serious because I got a feeling he's gonna probably tear stuff apart and I really want to.
Okay, Marshall.
I'm really not gonna
rebuild
do
it.
that this time.
Oh, okay, all right.
You know, for once I try to figure you out and you do this to me.
Sorry, I don't know what to tell you.
All right. Don't be sorry, we like it.
My testimony will be fairly brief. Like Dennis, I'm gonna go through not sort of section by section, but topically because there's some stuff kind of scattered through the sections that all address the same topics. So to begin with, I'll work from the sort of bottom up. I'll start with there's various sections in here that are meant to address the problem of communication between the courts and DMV around juvenile adjudications or convictions in either the delinquency juvenile court or in the youthful offender courts for traffic violations. We think this has been a problem for a long time, and it's been kind of funny where this problem developed. It's a problem that's developed in two places. It started out years ago where the judiciary there's a provision there was a point where we were making changes to the juvenile laws, and it didn't make sense that traffic cases were all held in criminal court, even though a lot of them were a lot less serious than cases that were being held in juvenile court. So we moved them to juvenile court, but then we put this provision in Title IV that says that the family jurisdiction shall forward a record of any conviction for a violation of a law related to motor vehicle traffic control other than a parking violation to the Commissioner of Motor Vehicles. And we thought we had addressed the problem there. My understanding of what happened then is the judiciary was sending notifications to DMV, but DMV didn't understand what to do with those notifications and didn't like getting notifications that were confidential documents because they didn't have the workflow to handle those confidential documents. So they said, please stop sending us these because we're not dealing with them anyway. And then a couple of years later, the legal interpretation at DMV changed. And they said, yeah, we do want these. But the legal interpretation at the judiciary changed. And the judiciary said, we've decided that these are not convictions because they happen in the juvenile court. And so we're not going to forward them on to DMV. I think all along, the intention has been for these to be forwarded to DMV. We've never thought otherwise. We've trained our attorneys from the day that this law passed. Your clients will be facing license suspensions. You should advise your clients they will be facing license suspensions. We then had to modify our training to say, your clients might be facing license suspensions. You should tell your clients they're going to get a license suspension because we think that's what the purpose of the law is. But in actual practice, it doesn't seem to be happening. So that's been our training up until this point. And we're happy to have this resolved so that we can give our clients real advice that we can be confident in. The one thing that I would add to the provisions in this bill is I might suggest just to make it especially clear, since this has been an area that I agree with Dennis, to me, I don't see a lot of, to me, the purpose of this law already is clear and makes sense, and I don't quite understand what all the back and forth has been. But to make it particularly clear, I think that adding an amendment to Title IV, Section 33, subsection B.
So is that, okay, 433B, okay. It's a page 3, 4, it's for 2 and 3, is that on the bill?
Well, let's see. I give it on page 3.
That's where we add using the subsection conviction,
Right.
the same meaning as 23 DSA 4, section 460.
And what I would add to that, is in the sentence before that, where it says the family division of the Superior Court shall forward a record of any conviction for a violation, et cetera, et cetera. I would just change that to conviction or adjudication, because then that definitely covers everything.
We like clarity.
So another whole sort of theme of this bill is addressing the issues of the up to 0.08 versus 0.08 and above.
Before you go to that.
Yes.
Marshall, so you're okay with the language that is in 33, section 5202, which is in page 20 and 21? I think those two are related, right? They're connected to each other.
Yes, we think it's we don't think it's necessary, but we think it's helpful.
Okay.
But I think we already thought it was pretty clear in the statute what was supposed to happen. It clearly wasn't clear enough. And so we're adding some things in. How many things we need to add in to clarify things that are already in statute is
Okay.
it's kind of a guessing game.
Okay, but you're okay with what we have
Yeah,
on.
we don't oppose it in any way.
Okay, thanks.
So when it comes to addressing the up to 0.08 versus 0.08 and above, we're 100% on board with clarifying that. That just sort of creates some consistency, first of all, between the civil process and the criminal process, and also just creates consistency around the state because we are having different judges interpreting that in different ways. And it's much better if we have some language that unifies interpretation around the state. So we have no objection to that. Then we get to the one place where we have some, I would say, quibbles, but not objections, which is all of the language around punishing failure to comply with a warrant as a refusal. So that's something that no other state does, to my knowledge. We support it in general concept because from our perspective, it benefits our clients because if we can find a way to punish them for refusal rather than obstruction or impeding, they're actually getting a lesser penalty and one that's more closely tied to the nexus of the offense. So we think more appropriate. We do have some concerns, though, that you can't actually penalize somebody for failing to comply with a warrant because a warrant doesn't direct a person to do anything. It directs law enforcement to do stuff. So if you read the warrant for a blood draw, it doesn't mention at all what a person has to do. It mentions what law enforcement has to do, what medical professionals are authorized to do, but warrants are directed at law enforcement. Warrants are not directed at individuals. I did a search on Westlaw to try to find examples of how courts have dealt with failure to comply with a warrant. And the answer is, in every case, when you find those words in a court decision, they're actually addressing police who have failed to comply with a warrant. Like, for example, if a warrant says shall be served prior to 9 p.m. and an officer serves the warrant at 10 p.m., then there's litigation about the validity of the warrant because the officer failed to comply with the warrant. But warrants aren't directed at individuals. So when you get cases where people have essentially tried to interfere with an officer's execution of a warrant, which is more what we're talking about because there's nothing in the warrant for the individual to comply with or not. It just directs an officer to obtain a sample of someone's blood. It's more if a person is impeding the administration of the execution of that warrant. And so I don't actually have a solution for how to fix that yet. I was working on that last night, trying to find language from other states that address this issue. And in other states, they seem to just address this by cause you to blow into a breathalyzer and you refuse to blow into the breathalyzer.
The audio was off in the corner. Gotta find out how.
Are we on now?
We are.
I think this is you, Marshall.
Probably.
We had the last time,
Probably.
we had the issue with the audio. It was you
30
again.
seconds, you said.
I'm emanating like 5 years on the way.
Wait or something.
Audio is on, I'll check the YouTube.
My electromagnetic spectrum.
So, all right, so I assume that that's on, I'm seeing that language on page 4 and on page 10. And can I have you and Dennis, with Ben, like, by early next week, try to come up with alternative language that satisfies all you? Does that work?
Oh, certainly.
Yeah. So we'll kind of put a pin in that one and schedule something for probably mid next week to circle back around to that part.
All right, and, by my reading, those were sort of the three issues that this bill really addressed. If there's anything else, I'm happy to answer questions about it.
Any questions on the bill? So I'll ask you my bigger question, and maybe you don't want to weigh in on today, but the conversation we had with Tom Oliver as well, just as far as implied consent and whether more of that can be moved to when the person gets a driver's license, or just to simplify the processing, or if you have any comment on that. If you don't, that's fine as well, because
I would be very cautious about any kind of a change like that, for a couple of reasons. One is that this area of law has grown more complicated, not because we have necessarily complicated it, but because the US Supreme Court has complicated it over the last few years. And so when we start to tinker with sort of the standards that are accepted around the country and that are the sort of standards that the Supreme Court addresses when it addresses these topics, I think we run the risk of finding ourselves kind of further out of the evolution of DUI law. I think the other thing about it that I would add is in terms of moving more of the applied consents.
So maybe my issue is, and we're fine with where it is right now. My issue, as I'm understanding from Tom Oliver, is the amount of processing, particularly when somebody may not be in the best position to be actually offering consent, that's something that perhaps needs a deeper look, and perhaps we can add a provision in this bill directing the appropriate entities, you state's attorney, well, Defender General, the court, state's attorney, maybe you can tell me who else, to go off in the off session and evaluate and tell us how, if anything, we can do in legislation to move that along, or maybe just asking folks to move the actual processing along consistent with the Supreme Court precedent and such. So
I'm sure we could do that. I mean, I do recognize I've certainly been on the receiving end of those phone calls, and I've dealt with some people who have had a real hard time being able to communicate legal concepts too. So I think there might be something we could do there, and we could certainly do something like that in the off session.
So we'll have you add that, Ben, to kind of start on that, asking some folks, some of the experts to get together for that. Yeah, Ian.
Just, did you have anything on the penalties, section?
Tell me which section you're looking at in particular.
Oh, are you looking at our document?
I hope so.
On 3, just on the serious bodily injury.
Oh, right, on the serious bodily injury, that, again, in terms of aligning the definition of serious bodily injury with the Title 13 definition, that's something that I think we had already assumed was law. And so it was news to me that it wasn't. And so we have no problem with that change.
Other questions for motion? And Tom, are you good with that, or do you have other ideas on?
Thank you.
On doing, okay. All right, thank you very much. Thank you very much, Marshall. Now we'll have Wade Cochran join us and weigh in on those parts of the bill that you wish to weigh in on.
Mine are fairly short now.
Okay.
They all took my thunder, so.
But we can add to it.
Yeah, I'm sure. So I'm Wade Cochran. I'm the Director of Enforcement and Safety at Motor Vehicle. And we'll go with page 2. Marshall brought up the adjudication. We don't disagree with that. But I'll believe it at that. We don't object, but we don't need it. the adjudication. So, let me go to reading through my notes. I'm sorry.
So you're saying you'd be fine if we added
We would be fine if you added it.
it, but you don't need it.
We don't
And
need it.
in hearing, it sounds like it could be good to include it though, so that it is clear depending on interpretation, if leadership changes and such.
Absolutely. More clarity is always good.
Okay, great.
And with that said, some of the past history that I believe Marshall brought up with the DMV not communicate or whoever wasn't communicating in the past, our system can handle this now with the new system that the past commissioner had started and now we're implementing. We can take those records now. So that's not a problem. And just skipping ahead, I think it's page 10 or 11. Get there. Okay, so it's page 11, under the 1205. DMV is also supporting some changing of the language in our miscellaneous bill right now. So we definitely would love to see the 08 or above, at or above change, and we're addressing that now as well. I'll go along. I think that might have been it. So
Right.
I just,
Sorry to have kept you here for that long, just to tell us that much. So appreciate it.
it's all good. Thank you very much.
No, any questions? Any other questions? Thank you very much.
Thank you.
Thank you. So two things before we break. I would like to, we may consider there's another couple of bills that revolve around DUI. One of them is H-123. And if not obviously looking for any comments right now, but if just giving a preview, we may schedule that for later next week. So if
We just get that yesterday.
yeah, we just got that yesterday. And if folks want to look at that and maybe talk about, I'd like to actually understand from the committee as well, if this is one we want to pursue and take a look at, since we're dealing with DUI issues. I would have, I'm not going to have Ben explain what it is right now. Or would that help? Yeah, Ben, why don't you, just join us and just tell us what 123 does. It's not a walkthrough, but it just kind of, so people kind of be. And do we have the .02 one? Is that one in here already somewhere and I'm just missing where it is? I think it is.
I can't.
Go ahead,
Bill number.
123 first and
105, it looks like.
Yes. Hi, Ben Novogrodsky from the Office of Legislative Counsel, back again. So H-123 relates to creating a civil penalty for a new charge called DWAI, which exists in New York, is driving while ability impaired. So it would be for those that have a blood alcohol content between 0.06 and 0.7079.
79.
079. 0.79.
we may want to get testimony on whether that's the appropriate range as well.
Right.
I know that Dennis Wiggins just the other day was talking about .05 being a place where impairment is generally established, but
DUI can be charged under the 08 now, right?
Can be charged under 08, but it can also be charged under the other basis of just under the influence.
So would this stop that from happening potentially?
Um,
Because somebody may be impaired, like you say, 07 or whatever. And when they would be charged with the DUI we have now, would this?
it wouldn't stop it.
Okay.
It would just provide another option.
yeah, it would essentially, from what I understand right now, it's when you get a .08, that's a presumption there that there was impairment. And what I'm saying, or what this bill would be saying, is that .06 and above, there's impairment, but the penalty is civil, not a DUI one.
Correct.
So
it would be a DUI.
right,
Yeah, so it would be a civil penalty, not a criminal one. That's the main difference of this new statute.
and I think the overall point is to say in our law that when you're at a 0.05, you're probably impaired and ought not be driving. I mean, yeah, maybe that's being a little general.
And maybe I just can't remember off the top of my head if it's 0.05 or 0.06.
It's what we have in there.
We debated.
A 0.06. So, and part of it is that I know increasingly people have those little things that they can blow in and tell you if you should, you know, I don't know if it tells you, does that, do those little devices that you can just purchase now tell you actually what your blood alcohol content is? That's what my understanding. And if somebody blows in there and sees a 0.06, they say, it's not 0.08, but I think that we just need to, so that's the concept behind it. And it's just a matter of looking at that. It's not something, obviously, none of these things we have to do, but that since we're talking about these issues. So Angela, go ahead.
I was just going to add for a little bit of, very little bit of background that this came up for me over the summer in learning about the fact that the United States is sort of an outlier in the world in terms of 0.08 being a fairly common legal limit. And, you know, Vermont is one of the states that has 0.08. Other states have lower limits. But just generally speaking, the United States is an outlier in the world in that 0.08 is quite a high level of intoxication for driving purposes.
Yeah.
So if the intent is to say that you shouldn't be driving at 0.06, why not just lower the DUI 1 to 0.06 instead of adding another complexity to the criminal to civil DUI? I am not saying that I support that. I'm just curious why add this.
I think the idea was that there would be a lot more pushback on making that kind of, if we keep it at a civil, it's still saying, hey, wrong. And I think that's, you know, that's it.
But you can also be charged under, I forget which subdivision it is, but it's under the influence. So yeah, A3, thanks.
So if you blow, so like right now, so let's say this went into effect. So you could blow, you could be 0.06, 0.062. You could get charged with a DUI 1 under the influence, civil DUI 1, and this what was it?
Well, not a civil DUI 1, so it would just be the under the influence criminal charge, and then the DWAI under this bill.
So if you, I guess I wasn't thinking of that. So if you have if you are charged with the under the influence, there's no equivalent civil DUI 1. You have to get the oath.
Right, yeah, because the only civil option right now is the suspension of the license.
Yeah.
So these are things we definitely.
Yeah, sorry.
Yeah, no, that's fine. I'm just trying to keep it at a high level, just a general concept and whether it'll work given, you know, those questions that you just asked, you know, if we dig into this. Yeah, Tom.
We always would just, if we get bad operation, that's all you need. Then that's what the case is built on. You don't need a test if you have bad operation.
Yeah.
And you can relate the two together.
Yes.
All of the numbers obviously help, but
Would you have them do a PPT?
if they are willing to.
Yeah.
Yeah,
I
Dennis.
could give maybe some historical context. The 0.08 standard is a function of a compromise between Mothers Against Drunk Driving and the distillery and breweries of our nation. They were essentially told by Congress, get together, come up with a number that you like that's lower than 1.0. There were some in Congress that were proposing the scientific standard of 0.05, which had been already adopted throughout the world in other places. But this was the number that they agreed to, and as a function, MAD, my understanding, is also agreed to never ask for a lower.
Well, Tom, did you?
Didn't we used to be 0.16 at one time?
1.0 and
That's an elevated
1.5.
impairment level now.
As far back as I can remember, anything like a 1.0 would be far down and above would be prosecuted. And now it's just come down a couple of ticks.
Right. For some reason I was thinking we were 0.16 at one time was the standard.
We do have an elevated 1.6, so if you have a 1.6 or above and commit an offense within, I think it's 2 years into the statute, and then you get an elevated or enhanced penalty and a longer term suspension.
So I'll try to fit that in just to dig into that one a little bit.
If nothing else, it'd be interesting.
Yeah. So since we're on DUI, we'll find some time to talk about that one. And the other one is H105, which is also kind of related to the issues. Do you want to tell us what that one is? Just
What's that?
an act relating to expanding the youth substance awareness safety program.
Yeah, so the purpose behind that is essentially streamline the youth substance, or not streamline it, but expand it to include .02 violations for people under 21 in family court. So to include them in the YSAS process, because right now there's sort of a separate process that sometimes leads to people subject to these processes completing one, but not realizing that they also have to complete the other. And so we just sort of streamline it in a way by expanding it and bring them into the YSAS program. So that everything they complete in that program would kind of take care of their requirements.
We'll need a lot more on what the YSAS program is.
Yes. And I will have that ready when at the
YSAS.
YSAS.
All right, so we'll just have a walk.
The youth substance safety awareness program.
So I think what I'll do is have some basic testimony, walk through and a couple people on those, just to understand what those, and see if we dig into them a little bit deeper. Just because I have a little bit of time for this afternoon, we're going to do H41, and Ben's has an updated draft. We'll go over the various amendments to that, and then one of the big questions for me, and we'll have Zone A and others perhaps weigh in on it. The only issue that's still sticking out, at least for me, is the mandatory minimum, and we'll just try to get some more testimony on that. And then let's see, we have one more person testifying on what we looked at yesterday, H25, a person who's the provider of the impaired driver rehabilitation program, to weigh in on that. Karen?
Yeah, so on that one, and I know we have somebody from DMV here today. I don't want them to have to speak to it, but also getting that voice on it.
Yeah, I think we'll do that after we get, we're going to try to get a fiscal note. I think when we come and return to it, we would do that.
Great.
I have some information on that.
Okay, all right.
But for later.
Okay, so tomorrow morning, we do have 3 people coming in on the hate crimes bill. Falco Showing from ACLU, Marshall's going to be in, Marshall Paul, and then Rodney Smola, who's the president of Vermont Law School and is an expert in First Amendment law, to talk a little bit further in that and see if we can get to a point where we have a bill we agree on, and probably schedule that for a vote early next week if we feel like we're there. And then in the afternoon, because I've given you so much time off, Ken, this week, that I figured I would go till 2 tomorrow afternoon. We're going to do H108, act relating to filial support, which should be straightforward.
Mr. Chair, are you sick of me at that point? Because that's Michelle. So I feel like it's just been me here. Now you've got Michelle.
Tomorrow.
Yeah. Well, no, in the afternoon.
You're a hate crime.
Yeah, no,
You won't admit to that.
I was gonna say, like, you've gotten sick of me. That way you had to sprinkle in Michelle at the end.
So just while I'm thinking of it, in case I forget this afternoon, and because I know Zach's not here tomorrow. So next week, we're going to be in the pavilion after lunch. It's a victims' rights day, and we're going to have a victim rights oversight hearing. And it will be folks on the network and Jennifer Pullman and probably some other individuals. The reason we're going to be in the pavilion is that we anticipate there's a lot of people in the building who want to sit in on that hearing, and there's not room here. So close to having room 11.
I was just going to ask, what are the timelines on that?
Not next week, the following week. Okay. Yeah, so close, but not quite close enough. So hope to then also vote H41, the use of corpse. We will, I do have, we know H44 possibly, but that's not gonna happen, because we need to look at that some more. And just also for a heads up, H98 is another one we'll take up next week, which is an act relating to confirmatory adoption. And H28, if we get to that. So folks know for their weekend reading pleasure.
All right.
And I think that's it. Well, let's adjourn until 1 o'clock.
Wow.